Hello, Brian Weeks here again with another MMCD contract consideration. This video clip will cover the topic of the importance of the agreement. In this short presentation, I'm going to highlight some of the critical features of the document called the agreement in the Master Municipal Construction Document regime. The agreement is the most important document in all the documents that form a complete construction contract. As such, it is vital that all parties, owners, contractors, and the contract administrator know what it allows and what it disallows. I'll also talk about the caution that must be exercised if the standard template form of agreement, which our association provides, is to be modified by an owner. So, just what is the agreement? It is the essence of the construction contract between an owner and a contractor. In just 4 pages, plus 2 lists, which are called Schedules 1 and 2, it sets out all of the critical points. It defines who is the owner, the contractor, and the contract administrator, and how they may be legally contacted. It sets out what work will be done, and when it must be substantially complete. It does this by defining what other documents are contract documents at the time of tender. Only contract documents have the power to impose obligations on one or both parties to the contract. So it's obviously critical to be clear about this. It then goes further to enable the parties to create additional contract documents by following the authorizations and processes an existing contract document creates. It also sets out how the amount the contractor is due to be paid will be calculated at any point. In return for the contractor committing to construct the work in strict compliance with all provisions of the contract documents, it commits the owner to pay in full and on time. But before we get to an agreement, there's something called a form of agreement. This is the document template which our association provides in an editable format on our website, www.mmcd.net. As the tender documents are being prepared, the tender author will edit the form of agreement to include the following: the contract reference information, the owner's name, the expected contract duration, that is, the time between the notice to proceed and the desired substantial performance date, the correct edition of the MMCD to incorporate, and most importantly, the list of other contract documents on Schedule 1 and contract drawings on Schedule 2. The balance of the information cannot be filled in until an award decision has been made. This form of agreement is important because bidders and their bonding companies need to know the rules of the game when evaluating what is to be done and the risks involved. Then, after the successful contractor is known, the tender author can fill in the missing data in the form of agreement. The name and contact information for the contractor is now known. The name and contact information for the contract administrator must be known by now as well. The addenda, which were issued during the tender process, are now known. And finally, knowing the expected date that the owner will issue the notice to proceed, and hence start the contract clock, the committed duration to substantial performance can be converted into a hard date and inserted into Clause 1.2. Because there was an offer, that is the tender, and an acceptance, that is the notice of award, and a consideration exchanged, the bonds, a legally binding contract is now in place. However, to properly complete the process, the now filled-in agreement must be signed by both parties. Our general conditions require that the owner must provide the documents in a form ready for signature within 15 working days of the notice of award. Failure to do this opens the door to a delay claim, as the contractor is not obliged to continue to work beyond the 15 days until the documents are received. Once received, the contractor has only 5 working days to sign and return them. Failure to do this puts the contractor into a breach of contract, and, on proper notice, the contract can be terminated. Once countersigned by the owner, a signed set of documents is returned to the contractor for its records. I've already stressed how important this document is. In fact, it is the most important document created. General Condition 2.2.4 sets out the ranking of the various documents which make up the contract documents. In it, the agreement is ranked number 1. This means if any other document contains elements which conflict with the agreement, those conflicts are null and void, as the agreement overrules everything else. Through its own conditions and the list of documents which form the contract, the agreement defines the scope of the work to be done and the risks each party will bear. Part of the risk analysis is done by the contractor's bonding company. If the bonding company feels uncomfortable with the risk inherent in the contract, they will either charge a premium for the bonds or refuse to issue the bonds for the tender at all. Because that risk analysis is done on the basis of the form of agreement, which is provided prior to tender close, no unilateral changes are allowed to be made to it subsequently. This means that if the standard form is to be altered, the tender author must get it right prior to closing. The MMCD Association strongly discourages owners from modifying the template language and expects tender authors to merely fill in the blanks. In fact, the association suggests that if owners have altered the standard language, this is so important that a special cautionary note should be created to advise tenderers of this change. Now, of course, any contract can be altered with the consent of both parties. So, if subsequent to tender closing, one or other of the parties wishes to alter the agreement, then the 2 parties negotiate until an acceptable adjustment is reached, or the effort is abandoned. However, in the case of MMCD contracts with the requirement for bonds, there's a third party involved. Any discussions about modifying the agreement should involve the bonding company, and obtaining its concurrence is wise. An owner does not want to provide a valid reason for a call on bonds to be refused because the bonding company perceived a change in the risk profile of which they were unaware or disagreed. A final note on this point is to the contract administrators. As I've discussed, the agreement is not a document that can be changed by one party. This means it is the one document that cannot be altered by contract administrators during the course of the project. I mentioned earlier that one of the most important portions of the agreement is the definition of what are contract documents and what are not. First, let me emphasize, a contract document binds both parties to the contract, and the contract administrator is put into a position of impartially evaluating the performance of both parties under the contract terms. Occasionally, I hear of owners who think that because they created the contract language, they have the right to pick and choose which portions apply to them during its term. This is not the case once the owner has set the terms and they have been accepted by the bidder to whom the contract was awarded. The contract is binding equally on both parties. No one party gets to choose which conditions will apply and which will be waived. If something is to be waived or modified or added, there has to be an agreement, at least on the method and the compensation involved. A key element of this is the definition of which documents are contract documents. The agreement lists some documents directly and incorporates others by reference. Only those documents which are defined in one of these ways by the agreement form the contract initially. All other negotiations, clarifications, etc., which came prior are now irrelevant, even if they were put in writing. Let's talk for a minute about documents incorporated by reference. Some are incorporated directly because they are so stated in the agreement itself. The prime example of this is the incorporation of the standard general conditions, specifications, and detail drawings in our Volume 2. These are brought into the contract because Volume 2 is specifically listed in the agreement. Other documents become contract documents because they are listed in a higher level document which is already a contract document. For example, many of our specifications refer to CSA or ASTM standards. Because they're called up in a contract document, they themselves become contract documents. The other point to understand is that when the agreement is created, only some of the eventual list of contract documents are known. These are what are listed in Schedules 1 and 2 to the agreement, along with any documents those reference. However, many new contract documents will be created during the course of the project. For example, field memos, change orders, daily force account forms, progress payments, dispute notices, and certificates of substantial and total performance, to name just a few. See example 1 on the slide. All these subsequent documents are legal contract documents because they have been created by someone who is authorized to do so by the agreement or general conditions. Of course, any documents referenced by one of these new legitimate contract documents become contract documents themselves. See example 2 on the slide. In this short video, there's not enough time to go through the agreement line by line. However, I will highlight a few other important points. The contractor accepts the obligation to do all things strictly as required by the contract documents. The only thing that relieves this strict obligation is a written waiver from the owner through the contract administrator. In return, the owner commits to pay in full and on time. Late payments generate an obligation to pay interest on the next progress billing. By signing this contract, neither party gives up their existing legislated and common law rights. So, for example, the owner's right to sue a contractor for defective work is not limited by the ending of this contract. It continues for several years afterwards, as set out in law. Similarly, a failure to act or an erroneous acceptance of a situation or condition does not become a precedent against correction or create a waiver of rights for either party. Finally, because the award of the contract is expected to be based at least partly on the experience of the contractor, superintendent, and their subcontractors, the agreement precludes the contractor from assigning the contract or any portion of it to someone else without the owner's express written consent. So to summarize, the agreement is the #1 ranking document in the hierarchy of documents. 2. Any change to the standard language of the agreement by an owner is strongly discouraged, and if it is done, an advisory should be made to bidders. 3. The agreement is the one document that cannot be unilaterally changed after the close of tender. Any changes thereafter must be done by negotiation and in consultation with the contractor's bonding company. 4. The agreement not only lists the documents, which are contract documents at the time of tendering, but also provides for new contract documents to be created during the term. Those new documents can incorporate others by reference, which then become contract documents themselves. 5. The agreement preserves all parties' existing rights under law. 6. The agreement ensures that mistakes do not become precedents, setting new acceptance standards, and do not create a waiver of rights. 7. The agreement protects the owner by preventing the contractor from assigning the contract or any portion without the owner's written consent. I hope that's clarified this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series. Thanks for watching.